The committee will come to order. I want to welcome our guest and welcome the members to what is undoubtedly going to be the first of many AI hearings. My staff, in preparation for this, knows one of my favorite jokes on artificial intelligence, which I was telling long before it becoming a direct issue for this committee, and that is that artificial intelligence is what members have when their staff prepares their opening statements. So yes, today we stand at the intersection of two rapidly evolving domains: generative artificial intelligence and existing copyright law that must adapt to it. The advent of generative AI technologies has sparked a profound transformation in the creation, distribution, and consumption of a new form of creative work. As we embark in our legal journey, along with the administration in their regulatory powers, it is vital that we explore the complex relationship between generative AI and copyright law, recognizing both the challenges and opportunities that lie ahead. Generative AI holds immense potential for innovative and artistic expression. It empowers creators to explore new frontiers, fueling their imagination with AI-generated content. Yet with the power that comes with it comes responsibility. Responsibility for negative activity on the web and of copyright laws being trampled. Copyright laws were designed to protect intellectual property. Copyright laws also exist under our Constitution specifically to encourage and then reward for creations. It's that encouragement that in fact creates the right of ownership, not the right of ownership having some core item. In this hearing, we aim to strike a delicate balance. Let me rephrase that in spite of what it says here. In this hearing, we recognize there's a delicate balance, and we would hope that our panel today represents both a diversity of views and a possible collaboration. We must consider, though, that there will be individuals on each side who will not want to move. There will be companies, which would include some of the household words, Microsoft, Meta, which is not yet a household word, but Facebook is, and in fact Google, that are on both sides of this issue, being both massive creators of their own copyright and massive users of others. It is our duty to adapt, refine copyright laws to accommodate the transformative potential of generative AI, while safeguarding the interest of existing creators and of the right of the society as a whole to benefit. Generative AI presents both challenges and opportunities for creative works and copyright holders. It requires thoughtful consideration and ongoing discussion with stakeholders to strike a balance between protecting intellectual property rights, encouraging creativity, and fostering innovative content, AI-generated included. Today, all of us here understand that generative AI is nascent. As we receive briefings, we hear about first generation, second generation, third generation, now fourth generation. And by the way, the education of this young child is profound, from something that was hard to understand to something that said the wrong thing to something that now is so usable that we might often forget to fact check its output because it seems so good. But we must, first and foremost, address properly the concerns surrounding unauthorized use of copyrighted material, while also recognizing the potential of generative AI can only be achieved with massive amounts of data, far more than is available outside of copyright. By embracing a forward-thinking approach, we can establish guidelines to promote responsible and ethical practices in the realm of generative AI. As we embark on our legal journey, let us approach it with a spirit of collaboration, as those who were on the call the other day clearly were doing. Let us find common ground, seeking solutions that promote the flourishing of both creative expression and intellectual property protection. The stakes couldn't be higher, and the outcome will shape the future landscape of art, technology, and copyright. Today, let us navigate this uncharted territory to ensure that generative AI and copyright laws foster in the future a fairly harmonious and vibrant ecosystem for generations to come. In closing, I might say that we clearly could have substituted patent or other areas of innovation and use just as easily, and we would have been having substantially the same hearing, perhaps in some cases with different witnesses. And in that sense, I think it's important for us all to look at this. I will close by saying that it has come to my attention that for once, Congress may not do either of the things we're known for, which is nothing at all or overreact. But that's not true around the world. Spain is moving forward with what I think might be a very restrictive interpretation. Japan believes, apparently, that all information that goes into the teaching is in fact free of any copyright restriction in its use. I do not believe that today's discussion will take us down either road. I believe that we will measure carefully and find middle ground that respects existing copyright law while allowing the future of generative AI to flourish. And with that, I yield back and recognize the ranking member for his opening statement.